Good afternoon, everyone. Welcome to the First Amendment Center's first event of the year. My name is Stephen Collis. I'm a professor here at the University of Texas Law School, and I'm the faculty director of the First Amendment Center. My goal for myself today is to get out of the way as quickly as possible. So I'm going to give very brief introductions to our speakers, who are some of the biggest lights in the field of law and religion, and hopefully don't need any introduction. But for those who are joining us either in person or online, we have actually a large contingent joining us online. Feel free to look them up. Very quickly, Professor Elizabeth Sepper is a professor here at the University of Texas School of Law. Nathan Chapman, immediately to her right, is a law professor at the University of Georgia School of Law. Michael McConnell, to my left, is a law professor at Stanford Law School. And on the far left is Professor Christopher Lund, who is the best of them all because he's a University of Texas grad and is a professor of law at Wayne State University School of Law. All of them, as I say, are leading lights in the field of law and religion, and all of them have dramatically influenced my own thinking on the Establishment Clause, as have many of our professors here, including Douglas Laycock and Larry Sager, who have written extensively on the Establishment Clause as well. So excited to have such a wonderful group here today. We're going to give Michael and Nathan about 10 to 15 minutes to introduce their book and some of their arguments. And then Liz and Chris will each have 10 to 15 minutes to respond, and then we will open it up for Q&A. For those joining online, I will be monitoring the Q&A. You can type your question right into the box in the live stream, and I'll see them, and we'll get to them, to as many as we can in the time allotted. So with that, Nathan and Michael, I'll turn it over to you, and we look forward to this. Can everyone please join me in welcoming them here?
So thank you, Steve, and thanks everyone for this occasion. It's especially good to see. I think I may have been in Doug Laycock's first class when he went into teaching, and Ward was my research assistant, and Larry and I have gone around the block more than once, although not so recently. So anyways, Chris is is a co-author on our casebook, and so it's great to be here among so many friends and colleagues. I think that there was a period in American constitutional law, roughly from the end of World War II until about the turn of the century, in which an understanding of the Establishment Clause took hold that really had very little to do with what came before and has largely been abandoned since. And I think this vision purported to be based upon an understanding of history. So this is one of the few clauses of the Constitution where people have not argued over whether historical understanding should be the principal mode, or at least the beginning point for understanding, but rather what does the history show? And the history that the Supreme Court relied upon, which came a lot of it out of the briefs of a very able lawyer named Leo Pfeffer, was, in our view, and one of the reasons why this book is a retelling of so much of this history, was a very distorted understanding that this view projected back upon the founding the secular versus religious hostility that has characterized more modern times, but it's very hard to find that division in the founding materials. So the way this played out is to create a tension. That's the Supreme Court's very frequently used term, tension, between the two parts of the religion clauses. So the free exercise clause under this view is protective of religion, and the Establishment Clause is suspicious of religion and tries to protect against too much religion in public life. If you look back to the founding, that would have astonished anyone engaged in the debates. So the leading advocates of disestablishment were also the leading advocates of free exercise, and they tended to be the most energetically religious sects in America. The Baptists were the leader of this group. The Presbyterians came around. But they believed that free exercise and establishment were two sides of the same coin and were mutually reinforcing. And they did not advocate this combination because they were worried about too much religion in public life. What they were worried about was too much government in religious life. And they wanted to prevent the government from either, in the case of free exercise, punishing people for their practice of religion, or on the establishment side, either coercing or controlling religion. So the main things that the Establishment Clause was understood to prohibit. And let me just stop for a second. Everybody's going to look at me. No, the Establishment Clause only applied to the federal government. So I'm going to be talking about what disestablishment meant. Disestablishment occurred at the state level, but it is our contention, which I'd be happy to defend, that when the framers of the First Amendment at the federal level used the term establishment of religion, they meant the same thing that term meant in the court at the state level. And so we can know, we have I think a wealth of understanding and information about what was understood to be an establishment of religion, even if it's all at the state level. And so, the key elements: people can't be required to pay taxes to a church. That was the biggest issue in Virginia, not the biggest issue elsewhere, but the biggest issue in Virginia. People cannot be required to attend a church. The government cannot control the personnel of the church. They don't choose the bishops, they don't choose the ministers. The government has no role. Religion, every single state constitution in a state that moved from an established church to disestablishment, each of those disestablishmentarian state constitutions provides that all religious societies will have the power to choose their own leadership. So that was part of disestablishment. Supreme Court only came to that view relatively recently, 2010, unanimously in the Hosanna Tabor case, but it still remains controversial in some quarters. So the government can't control personnel of the church. The government cannot control the liturgy of the church, right? And then there were some non-coercive. All of these are coercive. There were some non-coercive things that were regarded as part of the establishment. The leading ones that we can put our fingers on have to do with the use of the established church to perform various administrative functions, like keep the official records of births and deaths and weddings and so forth. In some places, the minister had a role in adjudicating property line boundaries and so forth. So this is where a particular denomination, because it wasn't just anybody who could do this, a particular favored denomination would perform governmental services. That's not, some of that is not coercive, but it was nonetheless understood to be an establishment. We believe that if you think about the underlying theme of all of these things, that establishment was, the central purpose of establishment was to create a uniformity of belief. The leading statute on this in Britain establishing the church is the Uniformity Acts, after all. And the idea was that the national ethos needed to be united around something as important to people's lives and to their thinking about politics as religion is. And so this is not designed to secularize. what it's designed to do is make sure that governmental power isn't used to direct people all into the same direction, that people should be able to decide for themselves, how religious they're going to be, what religion it's going to be. And that includes atheists, it includes non-Christians, it includes everybody.
So the book, in addition to arguing for a turn to history to understand the meaning of the clause, and then looking pretty carefully at the history of establishments in England, the southern states had the southern colonies, and then some of the states had Anglican establishments. The New England colonies had congregational establishments. Looking at those, and then looking at the disestablishment through the early 19th century in those states to determine, as Michael said, the understanding of disestablishment. We then turned to look at the contemporary doctrine, and I know we're going to have plenty of Q&A, and so I'll leave most of it for that. But we largely affirm the general trajectory of the current doctrine on the grounds that it is at least supported by the historical evidence and the sort of primary rationale for the clause of prohibiting efforts to induce conformity of religious belief. We take issue with a handful of things. One of the major shift in the last 30 years has been away from a one-size-fits-all test, three-part test called the Lemon test, towards more context-specific doctrinal tests, each of which is a little more historically sensitive, and each of which is also sensitive to this underlying purpose of promoting religious liberty rather than secularism per se. Be glad to talk more about the details in Q&A, but I want to be able to move on and hear what Chris and Liz have to say. So thank you both in advance, and thank you, Steve, for doing this, and special thank you to Sandra. All the preparations were perfect, so thanks.
All right. Well, first of all, it's a pleasure to be here. I am a UT grad and very, very pleased, and I feel like all my mentors are in the same room with Doug and Larry and Michael, and got suddenly nervous about this. So 2 parts to the book. I'm going to sort of get into the guts of the book a little bit more, because it's questions about the book's methodology, I think, where I guess I differ from the authors, and it ends up leading to some differences in application, or at least I think it does. So 2 parts to this book. The first half is historical, centered around the 18th century, offering a detailed account of what religious establishments were, and the second half of the book is application. It looks at that history, applies it to the various kinds of Establishment Clause disputes. And it's that point where the normative thesis of the book becomes evident, that the Supreme Court's interpretation of the Establishment Clause, right, starting the Warren Court, Burger Court, Rehnquist Court, was sort of wildly overbroad, and a historical Lemon and the endorsement test were unwise and should be junked. And generally speaking, though the book, there's some nuance here, the court's focus should be on coercion, that coercion should be a required element for the Establishment Clause claims, at least some of the time, maybe always. I'm going to focus again on the historical part. The Supreme Court is particularly interested in history these days. It wants to bring its conception of the Establishment Clause in line with that history. Several justices have already engaged with Michael's 2005 piece about the history of establishments that I think was sort of the seed for the first half of the book, although I'm speculating. And some praise. The historical part is really excellent. In 90 or so pages, it offers a really great summary of the history of the established Anglican Church in England, the religious establishments, both Anglican and Congregationalist, in the colonies, the passage of the First Amendment, the decline of state establishments of religion. This book does things a little differently than other books. There have been a lot of books about the historical meaning of the First Amendment, and most of them have been in pursuit of the framers, right? Trying to figure out what master principle they had in mind when they wrote the Establishment Clause back in 1789. And it's a tough job, right? That kind of historical analysis is always tough, and it's particularly tough with the Establishment Clause because the Establishment Clause's ultimate language differed from all previous versions. And that final language was hastily agreed to by a 6-person committee who left no record of what their alterations were supposed to mean. So this book does historical analysis a kind of different way, right? Instead of asking what principle the framers were trying to advance or create with the Establishment Clause, the book sort of focuses on the problem that that the Establishment Clause was meant to solve, right? The Establishment Clause was meant to end religious establishments. If we can just figure out what that term of art means, we have a roadmap for constitutional interpretation. All right, so to that end, the book talks a lot about sort of 6 categories of laws that it sees as making up a religious establishment. And Michael began to get into some of them, government control of doctrines, compulsory attendance, compulsory financial support, prohibitions on attending dissenting churches, using the established church for political functions, and restrictions on political participation for those in dissenting churches. Right? These are the laws that the Establishment Clause meant to forbid then. These are the kinds of laws and their contemporary equivalents that the Establishment Clause forbids now. But you can kind of see immediately how everything depends on the specific boundaries of the categories of these 6 categories. If you make the categories slightly broader or narrow, you end up with a totally different Establishment Clause, right? Like take compulsory church attendance, one of the book's categories. Later on, the book's going to say that the court was right to invalidate daily religious exercises in the public schools because that was effectively compulsory church attendance. But the court was also right to uphold legislative prayer schemes because that's not really compulsory. But, are we sure that compulsory church attendance is the right way to describe the category? I mean, it could be narrower. It could be like church attendance punished by fine or imprisonment. Because after all, in the school prayer cases, the prayers are compelled mostly by social pressure. And why should social pressure count? In Queen Elizabeth's day, failure to attend was punished by fine or incarceration. Why does attendance that's merely the product of social pressure count? Or, the category could be broader, right? Maybe instead of religious exercises put on by the state where attendance is compulsory, maybe it should just be religious exercises put on by the state. And if you draw the category that way, then all government-sponsored religious exercises, including legislative prayer schemes, become unconstitutional. So, here's the issue. The book is seeking to derive the meaning of the Establishment Clause by examining what it meant to have a religious establishment. And it associates these 6 categories of laws with religious establishments. But, why these 6? And why define them in the exact ways the book does? Right? Without a theory about what a religious establishment is, right, separate and apart from the 6 categories, I find it hard to test the claim that the 6 categories are actually what a religious establishment consisted of. Another example, if this is getting weird. In 1558, which I think is the very year of the Uniformity Act, Parliament begins opening sessions with prayer from a bishop in the Church of England. Do we take that as part of England's religious establishment? If we do, and why shouldn't we, then aren't Congress's chaplaincies, shouldn't they be considered part of a religious establishment? I mean, legislative prayers aren't any of the book's 6 categories. You're not going to strike them down. You wouldn't want that. But I don't know why. I mean, don't get me wrong. The court's never going to hold that Congress's chaplaincies are unconstitutional. But I just don't see what's wrong with that conclusion. That example pushes towards a broader Establishment Clause, but I could argue it the other way too. Right? One of their 6 categories is restricting political participation to members of the established church. And this definitely happened. English and colonial laws restricted political participation like this. Sometimes they excluded Catholics, sometimes they excluded Jews, sometimes they only allowed Protestants or a certain kind of Protestant to participate politically. Certainly these laws were terrible. Certainly people complained about them. But what makes those laws part of the religious establishment? I mean, is any law touching on religion part of the religious establishment? Well, then now I really want to know why Parliament opening up with prayer from a bishop of the Church of England again, why that's not part of the religious establishment. So the book, I think, really hesitates about offering a master theory. It's trying to get away from a master principle of the Establishment Clause. And I think that's a strength of the book, but I also think it's a weakness. And I found myself thinking about things this way. I'm not sure I'm right. But maybe there's a difference between what religious establishments did and what religious establishments were. Maybe the book's 6 categories are things that religious establishments did, but they weren't what religious establishments were, right? Maybe the most important things that a religious establishment did were coercive, but that doesn't mean that's all the religious establishment was. I mean, take compulsory church attendance, right? That old English law. Back in Queen Elizabeth's day, you were fined 1 shilling from absenting yourself, quote, absenting yourself from the divine worship in the established church. You can see, right, this language refers to a pre-existing established church, one that would exist even if there had been no requirement of compelled church attendance, right? As the established church, the Church of England compelled attendance, but that's not what made it the established church. I want to offer you a metaphor of a tree to describe religious establishments, right? The book's 6 categories are kind of the branches, but the trunk of the tree, right, from which the branches grow and sort of connecting the branches, what is that? And the essence of religious establishment, I'd argue, is something else, right? It's the government initially deciding questions of religious truth or advancing a religious vision. I think the framers believed that. Madison's memorial and remonstrance about how the civil magistrate is not a competent judge of religious truth. And I think that principle is what links the branches. But if you start thinking like this, you're going to come away, I think, quite differently in the application section of the book, right? If you start with the idea that the government doesn't decide religious questions, it's not going to be coercion that you end up with, but some kind of principle centered around favoritism, I would think. And I don't quite know what Michael and Nathan think about this. I'm sort of springing it on them now. Much of their book suggests that the Establishment Clause needs to cut back, and the decisions requiring coercion as an element of Establishment Clause adjudication, like in Kennedy versus Bremerton, maybe American Legion, those things are good things. But they might agree with me. I mean, there's one part, really just one paragraph at the beginning of the book that struck me on rereading. Right, back on page 18, just really offhandedly in a paragraph, they have this sentence that an establishment is the promotion and inculcation of a common set of beliefs through governmental authority. And I circled it, and it's exactly the way I think of it. But if you take this seriously as the definition of establishment, right? If you take this as the trunk of the tree, then I think it changes everything, right? Forget the 6 categories, right? If you start from the idea that the government can't promote or inculcate religious beliefs, it seems to me like the application section turns out very differently, right? Favoritism becomes the kind of principle, which is not far from the endorsement test and not far at all from Lemon. Maybe I've just given you my book on the history of the Establishment Clause.
All right. Everyone has been so concise, so I will try to as well. I want to add my thanks to Steve and to Sandra and to Michael, Nathan, and Chris for coming to Austin. I just came downstairs. The title of the book is Agreeing to Disagree, so I shall disagree, right? There's much in the book to be agreed with. There are many principles that I think we can point to, agree upon, that the history shows that these principles and practices were something that were viewed as establishment, maybe viewed as establishment consistently, maybe not, and I will unpack some of that. In some ways, though, the history recounted here is simple. Brief excerpts of debates are said to generate consistent commitments or understandings about practices that run through the entirety of U.S. history. And to read it, you'd think there'd been mostly continuity, the main disruption to religious affairs coming from the U.S. Supreme Court and no other quarters. But our country is messy and it is complex, and our history is messy and complex that I think this book somewhat dodges. So I want to offer up some of the complications, and I want to focus in particular on the issue of religious institutions. So with regard to institutions, the authors say, right, that state funding of religion is no cause for constitutional concern, and they tell us to quote, disestablishment invariably guarantees a right of self-governance to religious institutions, sometimes labeled in the scholarly literature as freedom of the church. And as is relevant to present day, they conclude that religious institutions should be freed from employment law as an unconstitutional intrusion onto church autonomy. They cite with approval Supreme Court cases involving not churches, but schools, and not actual ministers, but teachers. So the ministerial exception, often described, including in the book, as protecting the right of the Catholic Church to choose only men as priests, now labels nearly 100,000 women teachers priests of the Catholic Church, effectively. And this autonomy is a right to discriminate against women, Black people, disabled people, LGBT Q people and beyond. And in the wings is a right to discriminate against patients and customers as well. Now, in 2023, religious institutional autonomy is not about parishes. It's not about small local churches. It's about pension plans, insurance companies, multi-billion-dollar healthcare companies, and social services that receive 70% of their budgets from state coffers. It is about whether Bob Jones, a Supreme Court decision stripping tax exemption from a religious college dedicated to race discrimination, should be overturned. It's about the transformation of for-profit businesses into religious entities that can defy regulation and undermine public policy. And I'd suggest that many Americans throughout the time periods touched upon in this book would find this state of affairs to raise egregious establishment red flags. And I want to highlight, and maybe this touches on Chris's point, two major constitutional values related to religious institutions that barely surface, if at all, in the book. And those are concerns about the accumulation of wealth by religious institutions and the primacy of individual conscience over organizational interest. So the book presents the framers and those engaged in state disestablishment as primarily worried about the effect of, or maybe exclusively worried, I should say, about the effect of politics or government on religious institutions. But these men, and I use the term advisedly, of the Enlightenment lived very much in the shadow of the wars of religion. And the flip side of the coin, as they understood it, is that religion corrupted politics, uniquely risking political divisiveness, a principle that used to structure Supreme Court jurisprudence on the Establishment Clause. John Adams, for instance, devoted several chapters of his book, Defense of the Constitutions of the Government of the United States, condemning the horrors of religious wars, crusades, inquisitions, and pogroms. And he warned that unless they were guarded against, 19th century evangelicals would whip and crop and pillory and roast in this country as they had in Europe. Experience taught these Enlightenment thinkers that material wealth and political power were linked. James Madison warned that, quote, beside the danger of a direct mixture of religion and civil government, there is an evil which ought to be guarded against in the indefinite accumulation of property, given the capacity of holding it in perpetuity by ecclesiastical corporations. The Establishment Clause, of course, only applies directly to government actors, but it affects how the states think about structuring markets and subsidies to purportedly private actors. So as Sally Gordon's work shows, throughout the state disestablishment time period, and in some places into the 20th century, states imposed restrictions on church wealth. So even if strict separationism didn't govern, it was not remotely a system of church autonomy. There were both constitutional and statutory restrictions on church property. In return for incorporation, a church would take on limits to its income and property, including in a number of circumstances cited in the book. The Dartmouth College had limitations on its property. The hospital at issue in the Bradfield case also had very tight limits on its property ownership. And states policed church property to ensure it was used only for religious purposes, worship, interment, support of ministers, and no others. And so they understood that these structures denied to religious institutions the ability to gather wealth that sustained religious power. Congress seemed to agree. It disapproved a charter for the Latter-day Saints Church because it set no such limits on property holding. During the second constitutional framing, a time period that should be much more important to thinking about our understanding of constitutional history, receives almost no attention here. But during that time period, President Grant was so horrified by how much wealth had shifted to religious control during the Civil War that he focused his final State of the Union on this problem and proposed taxation of churches specifically to remedy it. And the 1870s and 60s saw conversations across the states and the adoption of taxation on churches, including by Congress in the District of Columbia, which resulted in Washington, D.C., foreclosing on churches that refused to pay the tax. So one establishment concern about institutions was this potential to accumulate wealth and transform that wealth into political power that would rival government. A second concern was the preservation of individual conscience against not just the state, but in organizational power, right? So the regulation of religious institutions doesn't just present a binary conflict between church and state, it also risks the tension between corporate power and individual religion or conscience. And this was another key concern that we see throughout our time period, including especially in the early 19th century. And this concern might be understood as underlying the doctrine of third-party harms from religious exemptions that Nathan and Michael dismiss as unfounded in the doctrine. But we see this commitment from the early 19th century disestablishment. States imposed internal governance rules on churches for the specific reason of ensuring individual conscience. And part of this was to ensure lay control over religious entities. So congregants, not clergy, had to control funds. This gave rise to many schisms. This was a cost of the benefit of preserving institutional conscience. Ironically, lay Catholics during the early 1800s embraced the trustee system because it allowed them to engage in localism and throw off the authority, sometimes the abuse of clergy that had been imposed upon them by the Catholic Church. Now, there were corporate governance limits in a number of places with rules for hiring and firing. Now, some courts came around to some level of autonomy, right? The hierarchy, the Catholic Church could send a priest to the church, but the lay congregants controlled governance in ways that meant the lay congregation could refuse to pay him. Now, some of these exist still today, right? The Catholic Church does not own Catholic hospitals, nursing homes, clinics, social services. These are separate corporations. Their assets would flow back to the public if they were closed or disincorporated. And due to nonprofit law, they are governed by lay corporations. This is part of the trade-off religious institutions engage in to accumulate power and affect individuals. Protection for individual conscience also took the form of what today we might think of as anti-discrimination. So Trinity College in 1823 was chartered as part of Connecticut's disestablishment. The charter said specifically that the college could not restrict either employment or admission to Episcopalians, the religion that Trinity College was affiliated with. And as states came to offer compensation to religious hospitals, as hospitals developed over the course of the 1800s, they refused funding to any hospital that would not agree to respect patients' consciences and often to admit to their staff any physician who wanted to join and was qualified. So both of these principles, these values, were understood to be at stake should religious institutions have unfettered autonomy, as it were. Now, just one final point, right? So what I see as distinguishing what the authors call the Supreme Court's reliance on a limited swath of founding era history, their invocation of Thomas Jefferson's wall of separation between church and state, and this book, is that the court didn't mean for the 18th and 19th centuries to be the only source of constitutional knowledge. And I'd be remiss if I just didn't note the problems with methodology overall. First of all, one would be hard-pressed, as usual in this area, to find women or people of color in this book. I found one quote that I noted. There's also inconsistency. To take an originalist approach to the Establishment Clause, and I know Michael takes a different view of the Free Exercise Clause as well, but free speech and free exercise are not tethered to this distant past. We had prosecutions for Sabbath breaking, blasphemy, fornication, to name a few distinctly religious penalties. We had the Alien and Seditions Act. It's quite clear that we're not using an originalist lens for the entirety of the First Amendment. Now, as someone who studied history for 4 years and has spent time in archives, I find history illuminating, but I am skeptical that rooting around in select writings of slaveholders and ministers is likely to generate universal constitutional truths applicable to a world that these men could not have dreamed up.
Okay, so we are going to move into the question and answer phase, but I have no doubt that Michael and Nathan will want to respond to Chris and Liz. So what we're going to do is, does anyone in the audience have a question? I'm going to call on someone. So Ward, but before Ward asks his question, why don't Ward and Nathan go ahead and respond to Chris and Liz, and then Ward, you can follow up with your question. I will be monitoring the online chat. I know many of you professors are used to using the queue system, but many of the students are not and don't even know what I just said. So we will not be using the queue system here. I'll call on individuals until we run out of time. We may go past, if it's okay with our panelists, I may go a little bit past 5. So those of you who have to leave, please feel free to do so if you can sneak out quietly. Is that okay with all of you if we have to sneak a little bit past 5, if it's a robust conversation? Great, so Michael and Nathan, go ahead, and then Ward, you can ask your question.
So you want to start, or show me?
Yeah, I'll begin.
Whichever way you want.
Sure, I'll begin, and I think what I have to say may be relevant to both of your comments, because you both obviously raised important questions about methodology and how we handle the history. I consider the book to be a primer on the history and the doctrine of the Establishment Clause, and there's a lot it doesn't talk about. As such, it sort of has what may be a dubious enterprise of trying to sort of taxonomize what governments did that was understood by those who were trying to disestablish to be components of an establishment. So what I think distinguishes, Chris, legislative prayers at the founding and the other things we identify is not that it was started by the English establishment, but that Americans who were disestablishing didn't perceive that to be a feature of establishment that needed to be eliminated because it was a threat to the same kinds of religious liberty concerns that the other features that they sought to eliminate over the course of the first part of the 19th century. So it's a combination of looking at what they said was a problem and then looking at things that they didn't say were problems and trying to identify to some extent what may be the underlying rationale. So we don't push, as you say, for a sort of single principle to rule them all with respect to Establishment Clause jurisprudence. But we do note that all of the categories we identify, with the possible exception of relying on religious institutions to enforce the law or to perform some civil functions. All of them have to do with either coercing or inducing a religious conformity. You emphasize coercion, and it's certainly a component of a lot of those, but it's not a necessary component of all of them. And especially, I think a central part of the establishment in England was the restriction of political participation on the basis of religious membership and whatever the privileged denomination was. You said one other thing that I wanted to discuss, again, at a kind of broad level, Chris. You said, get back to, what would it have looked like without compulsion? So in other words, wouldn't the establishment in England have looked basically the same way if the government hadn't required people to attend church services? And I may be misunderstanding what you said, but I think what's really important to understand about identifying what was and wasn't part of an establishment is that the establishment in England that became the pattern for establishing Anglicanism in the southern colonies, the Congregationalists had their own kind of more Calvinist approach, but it mirrored that in a lot of respects. It was a technique for conforming or unifying religious belief in a society of diverse belief. So the reason they used all of those tools was not because this is what the people would have done naturally if left to their own devices. They were dealing with a society that they felt like was being pulled apart, and through the Civil War and then the Glorious Revolution had been pulled apart by religious dissent. And so the legal techniques they used were, calculated to induce conformity among groups that were quite disparate. So on a sort of similar vein, Liz, you're quite right that the history is a little messier than we tell it. We sort of trim off some of the inconsistent, I think, practices, especially through the 19th century. So we talk a little bit, for instance, about the different approach that some states took with respect to whether to incorporate religious societies or to make them operate as unincorporated associations or trusts or something like that. There was diversity on that into the late 20th century. And so even though I think there was quite a bit of uniformity around the things that we identify as being features of an establishment, there certainly was diversity. And they came to understand some things as features of establishment later in time than right around the founding. So for instance, we mentioned anti-blasphemy statutes. By the 14th Amendment, Americans had pretty well decided that that was a vestige of establishment that was inconsistent with the kind of religious liberty that this establishment was supposed to foster. I'm interested in learning more about the laws that you're talking about states adopting in order to limit the amount of property that churches could hold. There was certainly a major concern throughout the 19th century was what they called an imperium in imperio, this idea that there would be some non-governmental private organization, whether it was religious or anything else, that would kind of grow up and become a source of power that was divorced from the republicanism that animated the ordinary political process. And so I'm certainly aware of a lot of those laws, aware of those restrictions. I'm not sure they were understood to be requirements of establishment, as opposed to just things that states could do that would not, interfere necessarily with the religious liberty of those religious organizations. And so, if the latter is the case, then you're dealing with, the area of the doctrine that the court has historically called, although that this area has narrowed to some extent in recent decades, the play in the joints, where legislatures have, some wiggle room to regulate religious organizations. You kind of refer to the freedom of the church theory, which we don't invoke and we don't argue against, but we certainly make a number of claims that I think the proponents of that would find to be inconsistent with their view. So I'm not sure that we're the exact target for all of the comments you were making, but I'd love to hear what Michael has to say about that.
Well, that was so thorough that maybe we should just go to the questions and answers.
Okay, well, welcome, guys. Sorry, welcome. I've been enjoying your book, and as I mentioned to Michael on the way in, I noticed that the book was not, for reasons of space or timing, able to reach the question of charter schools. I'd be most interested in how you think that question should be analyzed, because it strikes me as soon to be maybe the next great controversy in this field. Let's imagine by charter schools, what I mean is you have a state funding a school 100%, and it's an evangelical Christian school, or the state proposes to do that. It's allowing lots of other charter schools. Is it allowed to do that? Is it required to do that, in your judgment?
So we talked a little bit about this beforehand, and some of what I'm going to say was will be channeling Doug Laycock, whose wisdom on many of these things I have profited by over the years. I used to think this is an easy question because charter schools are part of the government, and the government is on the government side rather than the church side of the separation between church and state. And I now do believe it's a harder question. I'm not at all settled in my own mind. I think a great deal depends upon how the charter school system is set up in general. So who can start a charter school? What is the range of choice with respect to charter schools? How much control does the state have over charter schools? And I just don't know the answer to those questions, but I think that's what we would need to look at in order to give a serious answer. So I used to view them, they're government schools. Okay, that answered the question, but Doug pointed out that you can also view them as government-funded private schools, that they're within the system, but the government hands out the funding, but the whole purpose of the charter school movement is to allow schools to flourish within the system, departing from, they don't have the same curriculum, they don't have the same requirements for hiring, et cetera, and to the extent that that is an accurate description of the system, I think they may have a good argument.
Okay, thank you. Is there another question in the room? So we see Doug. Why don't we go with Doug Laycock, and then I'll have a question after that from somebody online. The question online is for you, Liz, so get all psyched up for that. But Doug, go ahead.
We've come out over the years on opposite sides of establishment clause questions. I obviously agree with most of your history. It's accurate. There's more to be said, as both Liz and Nathan said, but it has always seemed to me that each of your 6 categories have their modern equivalent. And that's part of what Chris was saying, right? There's compulsory church attendance enforced by the threat of fines or imprisonment 1 hour every Sunday morning. There's compulsory religious attendance if you can't do business with your city council without sitting through somebody else's prayer service for 5 minutes. The second one is much more attenuated than the historical one. In principle, they seem very similar. And so part of the question here and part of the different reason for our sometimes disagreement is how far out do you pursue the principle that these things were establishment? And your position seems to be it's got to look an awful lot like the late 18th century. It can't change much without becoming no longer an establishment. And I would approach that question a different way. One thing that seems clear from that time is they thought the government should stay out of religious controversies. You see this in their behavior. Things that Protestants disagreed about became big issues. Things that Protestants didn't disagree about didn't become big issues. Madison and others said the government's not a competent judge of religious truth. Well, part of what's changed is we have a whole lot more religious controversies now, in part because of greater pluralism, the greater number of different religions, in part because of the rise of secularism. So, 30% or so of the population is taking an essentially negative view of the great religious questions, but they still got answers to the great religious questions. And much of what the endorsement test was about and what the two prongs, the two neutrality prongs of women, neither advance nor inhibit religion, it's about keeping government neutral as among these modern religious controversies. And it seems to me that's where, that's the part of the issue that the book doesn't seem to get to, and that I think might lead to some very different conclusions.
Maybe let me just respond to a little bit of this. So Chris said something and that I want to clarify. I'm not sure we said this before, but I don't view the 6 categories. You said why 6, why not 7 or 8? I don't actually view the 6 categories as if it's not there, it doesn't exist. These just happen to be the things that are very prominent in the history. So we do know about these things. Maybe there are some other things, and I'm perfectly open to it. On the other hand, there are some things that people might think are establishment problems that that there's pretty good evidence that they didn't regard as an establishment problem. I think that's not just being left off the list, but that's I think that's a considered judgment. Like, we know for sure that they did not think the government support to religious higher education was part of establishment, because the very people who are arguing for disestablishment also, supported this. And the Baptists were the biggest disestablishmentarians, and they got funding for a Baptist higher education. We could talk about why, but I think that's the conclusion. Doug mentions municipal, city council prayer. I think it's an extremely bad practice, and Doug may be right that it was unconstitutional. That's not quite the same as legislative prayer. People don't go to the public at the, who are in the attending the House and the Senate are not there under any kind of compulsion in the way people are in order to go before a city council. These were points that Doug made in his amicus brief in Town of Greece against Galloway, which was so much better an argument than the arguments that the Second Circuit had made or that the respondents made. And the Supreme Court didn't deal with it because it wasn't raised below and wasn't the argument of the parties. It might have been a very good argument. I think we need to know a little bit more about the reality of coercion there, but I'm perfectly open to this. In fact, when Marsh versus Chambers, the original legislative prayer case, came down, I said it was wrongly decided because the Supreme Court didn't have a theory. When it came to Town of Greece, they offered a theory, and I'm not as unhappy about Marsh as I was. I think it's interesting that in Town of Greece, I expected the dissenters to, build on all of the criticism of Marsh. But instead, they all say, oh, we're all for Marsh. They don't just say we acquiesce in it because it's a matter of precedent. They actually say they agree that Marsh versus Chambers was correctly decided. I don't know. I strongly believe that the government cannot take, as part of disestablishment, totally agree with both Chris and Doug, that part of that is that they can't declare religious truth. And I also agree with Chris that this is very closely related to the principle of denominational equality. That is one of the six, by the way, is the insistence upon non-preference among religions. Now, that's not the same as neutrality between religion and non-religion, but neutrality between religions is I think one of the bedrock principles of the Establishment Clause, and therefore I'm not sure we have as much disagreement as you might think about that. You ended on something else, Doug, that I'm forgetting.
No, I think that was it. But I think denominational equality and equality among religious views get you to the endorsement test very quickly. And you appear not.
Well, unless you buy our argument that there is a difference between you can say I like Cheerios without necessarily saying that there's something wrong with cornflakes. Expression of good, saying something nice about something is not exclusive, right? And so I think the idea that including a religious symbol in a holiday celebration is dissing everybody else is simply a misunderstanding of the meaning of social symbols.
If I can
So
briefly
Chris asked for a very short response.
Did you want to go?
A very short one, and then I would like to give Liz a chance to answer this question from one of our online users.
Yeah, I see things pretty much the way Doug does. I'm glad you say all this about the 6 categories and how there might be other categories, and it makes sense. I mean, our book has 4 categories when we're talking about the establishment and sort of the six in different forms or whatever. I think the problem that's coming up, and what makes me a little nervous, is, Justice Gorsuch in his concurrence in the Shurtleff case, the Boston flag case, is, he announces a sort of full-blown theory of the Establishment Clause, and it's your six categories, and he says really what links them is coercion. And I don't think that's what your article in 2005 said exactly, and I don't think that's what you're saying here exactly, but it feels to me like that's sort of where some of the members of the court are going. Also, you do see in the book, and you talk a lot about how you see a distinction between endorsement and favoritism. I have to say, I tend to see those two things. I think what you say is that you can endorse things without showing favoritism to them, right? And I have to say, that is not my intuition. I always see the endorsement test as a test about favoritism with a metric, right, the reasonable observer to gauge whether there's been favoritism. So on that, I think it's interesting that we see it differently.
Yeah, it's slightly different, I guess, response to Doug, although this overlaps with Michael's. And Michael and I don't think agree entirely about symbols, which we can talk about at some other time maybe. But with respect to your question about legislative prayers, and it goes to symbols too, Doug, sort of what are the outer boundaries of whatever these categories are? How do you know when you've met them? I mean, there's a risk of reifying the categories like doctrine, and then, when doctrine becomes reified, it like replaces the thing it's actually supposed to enforce, and then over time it gets like further and further away from the rationale. My view about the categories is that they go as far, generally speaking, as the underlying rationale. And I see the underlying rationale as being much like what some guy named Doug Laycock described one time as substantive neutrality. That raises, which basically is a kind of, I'm going to describe it in a way that would be ineffective in your mind, probably. But in any case, I largely agree with it. And I think it has to do with not sort of inducing folks to change their beliefs or practices one way or the other, to where whatever the government is doing, it's sort of as out of the market of sort of free decision-making about that as much as possible. The concern about the specific example of Town of Greece, and it may be the concern in a lot of symbols cases, I think. So even your description of what's wrong with those is that they're like forcing someone to attend a worship service, compelling them to do it. The concern is that folks feel like they are obliged to pretend to go along or to actually go along because they will be discriminated against by that person or by that body of people who put this symbol up. And I see the endorsement test at its best as being a bit of a prophylactic doctrine that says it's really difficult to know when that kind of discrimination is in fact happening for lots of reasons. Are they being reasonable with respect to their apprehension of such discrimination? In my view, that's kind of the best justification for something like the endorsement test. I'm not sure I would use the word endorsement, but it amounts to kind of, is the government effectively threatening people with discrimination? And the problem with that is it induces them to change their religious beliefs or pretend or conform or whatever to whatever the government's preferred view is. Thanks.
Okay, thank you, wonderful. Yep. So we have people who are joining us from across the country online, and someone who didn't give me a good username list, so I can't tell you who it is, has a question. It says, question for Elizabeth Sepper. You mentioned the Catholic Church quite a bit in the discussion of historical practices that focused on limiting religious institutions, but did not discuss any of these in the context of the heavy waves of anti-Catholic sentiment that was also intertwined throughout those areas. With the fact that state governments often took action to explicitly target the Catholic Church in particular affect how you view some of those historical options in terms of their legitimacy as an enlightening example of how to truly understand the Establishment Clause?
So the time period I was talking about, the mention of the Catholic Church came in the early 1800s, so consistent with incorporation statutes that applied to all kinds of churches, but had particular rigor for Catholic churches because of the hierarchical nature. Lay governance meant a great deal more by way of religious freedom and control over resources for individual Catholics in the early 1800s under these statutes as part of the state disestablishment. This is probably a reference to Blaine amendments that were adopted in a variety of states, but that time period is much later than what I'm talking about, so near the 20th century. And those amendments had some states had prohibitions on funding for Catholic institutions before then, or sectarian institutions. Now, it didn't prevent all funding, so hospitals are the areas I know best, and what tended to happen was, to the extent states funded hospitals, they funded their secular services. And in fact, Catholic hospitals did not view themselves as sectarian organizations either. They viewed themselves as secular organizations. And we see this in litigation from sort of the early 20th century onwards, where they say quite clearly, what we're doing here is secular. We're a secular institution. We are non-sectarian. And so even states that had prohibitions on funding, for example, for Catholic or for sectarian hospitals, which wasn't focused on Catholicism when it comes to hospitals, would fund them throughout the entire period. So the Blaine amendments were not a prohibition on funding Catholic or even what we might today think of as sectarian institutions overall. So sort of movement over time.
So about the lay control issue, this was a huge controversy that lasted maybe 75 years. I think it got kicked off in about 1820 or so and wasn't resolved for a very long time. And the attempt by Protestant legislatures to force the Catholic Church into a model of lay control of the property was part and parcel of the same anti-Catholic movement that led to the Blaine amendments. I just don't. It's a different thing, of course, but all of this was the idea that Catholicism was deeply inconsistent with republicanism as understood in the United States, and republicanism meant such things as lay control. Maybe I'm speaking too much as a Protestant here, but it just is. I think it's simply a fact that the Catholic Church was a hierarchical institution, not a Republican institution, and to try to make it into a Republican institution is to try to turn it into a Protestant church. So I don't think we should at all look at that history as an indication of a part of disestablishment. What it was a part of the Protestant hegemony, which was, I think, a form of establishment. As to the hospitals, I don't know. I'd like to see the footnotes that show Catholic hospitals in the 19th century. Is that what we're talking about? Saying that we're secular institutions, like the Bradfield versus Roberts, which is the only case that I know about. This was the mission operation of a society of nuns, and what the Supreme Court said is that the fact that this hospital is controlled by a religious group, namely an order of nuns, is immaterial to the question of whether it would be an establishment for it to receive government funding.
So on this specific point of Bradfield, right, the hospital at issue in Bradfield, Providence Hospital, had been incorporated as a secular corporation. It was not a religious corporation, and that was a large measure of what drove what is a very strange and formalist decision. But it doesn't hold that the Establishment Clause doesn't bar funding for religious institutions. It holds that this institution is a secular institution because the corporate charter dedicates it to providing medical care primarily for the poor, but also for paying patients. And that's large measure what we saw over time. The statutes I'm talking about of the early 1800s are general incorporation statutes that apply to all sorts of churches. Catholic local parishes were very excited to get access, of course, to incorporation during the time period. It came with trade-offs, like all things do. And I think we've seen the same trend as we come into the 20th century, where we see the Catholic Church spinning off a number of corporations, hospital corporations, social services corporations. They don't own any of these. For liability reasons, they wanted to detach themselves. And they, again, through processes of incorporation as general nonprofits, accepted lay governance. So Catholic Charities is lay governed. Catholic hospitals are lay governed. It's sort of part and parcel of the same kind of dynamics that we saw in the early 1800s, but modernized for today, again, with an understanding of trade-offs between full-scale religious identity and secular services and funding, in my view.
Okay, I know we are pretty much out of time. Do we have time for maybe one last question if somebody would like to say something or ask a question of the group? Hearing none, everyone please join me in thanking our panelists.